Hello, and welcome back to Coin Lady channel. Is there any conceivable scenario in which you would part with your XRP? Willingly turn yourself into the SEC? Could you imagine doing that? XRP, SEC getting it? What if it rains? There's a good cause for my inquiry. Your question reminds me of a topic I discussed on my channel not long ago. It's been making waves in the XRP community for the past few days and concerns the other Ripple-related case, not the SEC complaint. However, I elaborated on the ZK-off situation. Therefore, I will merely establish the table briefly and then go to the new material. What's important, though, is the history of the ZK-off case, which goes back, at the very least, half a decade. It was a class action, or a push for a class action, alleging that Ripple offered XRP as an unregistered security before the SEC versus Rybolt case. We learned only yesterday that the court has indeed certified the class, thus things are finally moving forward here. But would there be any actual advantages? For example, suppose the SEC is successful in its efforts to defeat Ripple. And there's a scenario in which the SEC's assertions that the $1.3 billion or so that Ripple obtained illegally are true. Do you think the SEC could ever understand that? And by giving them your XRP, you find tranquility? Well, attorney John Deaton recently discussed this same topic, so I'll give you his in-depth viewpoint, and he doesn't hold back, as you'll see. However, I must state up front that I do not come from a financial or legal background. I am not qualified to give you financial or legal counsel. And you know that you shouldn't make any financial decisions based on what I say, right? I'm just a fan who occasionally posts videos to YouTube regarding crypto-related subjects for kicks. Okay, so what did we end up talking about? Who or what provoked this? Well, an XRP community member named XRP Wing Commander tagged attorney Deaton and asked if this verdict goes against Ripple, and the judge says XRP is a security, could we find that more XRP holders joined the case that are suing Ripple in Oakland, California, rather than waiting for appeal via a Supreme Court decision around the year 2030? Because of the availability of a choice, this also makes sense. So, may some of the 75,000 or 76,000 XRP holders that John Deep represents be affected by a bad rule in the SEC versus Ripple case? The class has already been certified, so if there is a poor ruling here, they might potentially join in and throw this ZK case out. This seems to be progressing, right? So, let's hear what Deaton, the attorney, has to say about it. If Ripple loses its case with the SEC, it will be years before any funds are collected. And only if the appeal is denied for Ripple. If Congress doesn't act by the time the case reaches the Supreme Court on appeal, I think Ripple would win by a landslide. Ripple will appeal a decision in favor of the SEC. And the present status quo will persist for the next 2 to 5 years. Alright, so we have a spaghetti note. When considering the current composition of the Supreme Court, I find myself in complete agreement with attorney Deaton. Simply put, they oppose any and all forms of tyranny by the state. You can see the outcome of a similar lawsuit involving the EPA from a year ago. The Supreme Court will slap any government agency that tries to overstep its authority. This is exactly what will occur. That's what I fully anticipate happening. The catch, of course, is that he also mentioned that this would take some time, somewhere in the range of 2 to 5 years. Whoa. That's why I keep repeating that I wish there were more transparency. I really need this to be finished, though. From what I've read, it seems like a lot of people out there share my opinion. I really just want this to be over with, so here's hoping that the SEC doesn't appeal if Ripple wins, or that if they do appeal, it's simply a show of force before they give in and try to negotiate a settlement. That's not to say it couldn't happen. But in any case, the Deaton tournament keeps going. If the SEC prevails and the civil lawsuit lawyers succeed because the court in California agrees with them, Ripple will appeal both decisions. If Ripple loses all appeals, the SEC, not the civil suit, will get the $1.3 billion in damages 5 years from now. So here's something to ponder, folks. Even while the class has been certified and the Zach enough case has been heard, that doesn't indicate the plaintiffs will necessarily prevail. Not at all. We are a long way from having it. Simply put, this implies they can effectively argue on behalf of an individual XRP holder who meets certain requirements. Now we're done. So, if Ripple is unsuccessful in its appeals, and if that happens, we could be looking at a lengthy legal process lasting anywhere from a few years to as much as 5. If that's the case, Ripple will have to fork over a cool $1.3 billion to the SEC rather than the civil litigants. Indeed, he is referencing just that. In addition, according to Attorney Deaton, the SEC would provide a buyback fund for XRP holders to liquidate their holdings. In Veritasium, this is exactly what went down. It's a separate crypto scenario that I brought up a few times on the channel. He argues that if he were representing the plaintiff in the civil case, he would prefer that the SEC lose in order to collect the damages for the relatively minor issue at hand. It seems contradictory, but if you're the lawyers representing Zach in the SEC lawsuit, you want them to lose. Why? Here, Attorney Dean sheds light on the matter, so read on. In a twist of fate, XRP investors would benefit more from the SEC fund if there was a rebound. This is because, in a civil action, attorneys typically receive between 25% and 35% of any money recovered as fees, and this is before any expenses are deducted. If Ripple is successful, the Zach case could still be delayed. And if that's the case, also, it can handle the workload. I know. It could appear absurd at first. But even if Ripple prevails, there is still a chance that this case can move forward. This is when the lawyers may receive their 30% to 45% share of the profits. So that's what drives the lawyers, then. Of course, the enormous windfall would come primarily at the expense of XRP holders, but it may theoretically change their lives for the better anyway. Again, if there was a recovery, as Attorney Deaton notes, and as he discusses, I believe, a little bit more as we proceed, then this would be a different story. XRP holders would fare better if the SEC were in charge of the situation as opposed to, say, lawyers in this economic issue. Do I need to explain why that's absurd? It's a fact though. Again, the reason I just gave is so that the Zakonoff lawyers don't receive a cut. That means a lot more cash for people who own XRP. Let me be clear, I do not believe any of this is desirable. And I think I know obviously that the majority of us think that what's happening here is just frivolous lawsuit foolishness. But this is only a thought experiment. This is only a mental experiment, a game we're playing to help us think things through. Attorney Deaton is discussing the what-if scenario. The possibility exists for this to occur. Unlikely though it may seem, the events detailed here are not impossible. As stated here, this makes it easy to identify a large putative class of XRP holders, which is why, as Attorney Deaton points out, her client's inclusion on the 75,000-person list is a good thing. By signing up for the class list I distributed, no one gave up any rights. You'd probably contact me if you ever recovered money for XRP holders, whether in a civil action or an SEC lawsuit, because you're required by law to notify XRP holders of the recovery. I also have access to a list of 75,000. Ignore the dummies who think it's a terrible idea to join the 75,000 people who are claiming that XRP isn't a security. In the event that XRP holders experience a financial upturn in the future, it's clear that these idiots are completely off the mark. Someone may consider their asset to be non-security status. The current situation has me completely lost. Where do my eyes go when I scroll down? At last, we've arrived. Someone may consider their asset to be non-security status. However, if it turns out that the judge and the appeal court disagree, you won't face any consequences for being mistaken. You would not be disqualified from selling your XRP to the SEC or back to Ripple in the event of a lawsuit just because you signed a list claiming you could not. Whoever tells you otherwise is just plain stupid. I think that's pretty clear to everyone, by the way. If you're mistaken and insisting that this isn't a security flaw, then you're wrong. Even if the court rules against you, it doesn't mean you're without recourse, whether monetary or otherwise, simply because you held a different opinion. I think that helps to clarify things a bit. We'll get to the reasons for the attorney's frustration in a moment, but suffice it to say that I sympathize with him. Certainly, he said, but the truth is, I doubt the civil case results in anything. If the SEC prevails, it will earn the most money and be in a position to provide the. Ironically, even if Ripple loses and Congress cleans up the regulatory muddle in the 5 years it takes to hear appeals, the whole thing will go away by itself. In the end, simply being on the list didn't imply anything. And if I'm reading them properly, being on that list would make it more likely that you'd really get some form of reimbursement should things go this way. Also, if you have any claims, you probably already recognized them. And I did say the other day that if something like this happened, I wouldn't be participating in any form of compensation. But there's one catch. After being briefed, I thought, that just seems so unethical to me. I may be wrong about this, because I'm not a lawyer, but if it turns out that Ripple's funds are going to be stolen regardless, my calculations would change. I feel like I need to cry, but I don't know how to do it. And I really doubt that this will happen. But if it did, I'm just saying, if the SEC has the money and if Ripple doesn't, then I wouldn't feel like there's anything unethical going on. My tears, my XRP, give me back the money that was once Ripple's, and I would feel awful about it. I would feel like I've gone too far if it were being ripped out of the sand solely because I went along with it. And now it's also immoral to do so. Having said that, let's see how this develops further. So let's game this out a little bit, even supposing that were the truth and you could actually hand over your XRP to the SEC and get anything because Ripple ultimately paid that $1.3 billion. Would doing so help your bank account? Or is there a risk that in 5 years' time the entire asset class, including XRP, will be worth so much more that it would be foolish to provide any of it to the SEC in exchange for a small piece of what was once Ripple's money? Isn't it preferable to simply sell on the market? Whether or if that choice would be available in the United States is an open topic. At this point, we have no idea, and it could be half a decade before we find out. But, look, all I'm saying opportunities, I believe, would still be present. Therefore, in my opinion, the answer is not yes. There are so many factors working against me that I seriously doubt I would ever accomplish something like that. If it were something that may hurt Ripple, I'd feel horrible about myself. So my answer is still no, but if they've already been harmed, then it's just like, okay, well, either the SEC gets to have this, I don't even know what happens if it's not claimed or what, or maybe if I don't claim mine, it just means a bigger piece of the pie for anybody else that does claim and give the extra P to the SEC. And then there was Attorney Deaton, who remarked something to the effect that perhaps I'm being a little harsh by labeling them morons, etc. But when I start getting dozens of emails and phone calls at my office because people have been told by someone, including lawyers, that they screwed themselves by adding their name to an amicus class or signing an affidavit stating they don't regard XRP to be a security, it's simply not accurate. In light of this information, I can understand why he is contacting certain people more frequently. This is an effective attack against him since he is. And there have been calls to his office. Whoa. And then, can you picture the amount of time that's sucking out of his day or days just to try to contact this? So if any vet you out there listen, if you had a problem because you signed up, and Attorney Deaton is defending you, do not be afraid. It's all good now. You did yourself a favor, if anything. Even though I don't foresee this happening, I should keep my mouth shut just in case. No, I don't give out financial advice. Please like and subscribe my channel. See you later, bye.